Good morning. Thank you so much for joining us today on our Wednesday webinar, where we will discuss Social Security disability for arthritis. Before we get into it, I do want to make our typical reminder, which is that this webinar is not intended to be legal advice, but is instead intended to serve as additional background information regarding Social Security disability claims and arthritis. On the live webinar, I do not answer any questions, and I can't answer really many questions, specific questions in the comments on the replay. And the reason for that is not because I don't want to help, because I do. The reason for that is because typically I need a lot of information in order to provide a good answer to your question, an answer that you're going to be satisfied with. And so to that end, what we'll do on the live is we'll go ahead and drop it in the chat now. And on the replay, we'll drop it down below where it's a link where you can go ahead and schedule a call directly with us where we can go ahead, answer your questions, figure out what information we need from you to best answer your question and get you the best answer we can. So that is why we don't take any questions on the live, and I can't really respond to many questions on the replay. It's not because I don't want to help, but it's because there are specific information that we tend to need in response. With that being said, here's where we're going today. First, we're going to talk about some Social Security disability basics. We'll talk about some guidance from the agency. We'll talk about listing 14.09, which is the listing for inflammatory arthritis. After that, there will be another slide with the 3 other potential listings that you may want to look into, specifically if the arthritis is in your back or one of your major joints like your knees. The other listings that we don't explicitly look at might be something helpful to look at for you. Then we'll get into considerations. And then finally, of course, we do end with how an attorney may be able to help you with your disability claim. A little bit about me. My name is Caitlin Wildoner. I'm the founding attorney of Beacon Disability, PLLC, which is a law firm based in Florida, where we exclusively practice federal administrative law, meaning we help clients with their Social Security disability insurance and supplemental security incomes, applications, claims, and appeals from the initial application stage through the appeals council. If you have questions, please do use the link that we put in the chat on the live, and that will be down below on the replay to see if it's something that we can help with. If for some reason it's something that we cannot help with, we do try to put you in touch with somebody who may be able to help. Okay, turning to Social Security disability basics. There are 2 different Social Security disability programs. There's Social Security Disability Insurance, or SSDI benefits, and then there's Supplemental Security Income, or SSI benefits. Both programs are going to require that you be disabled and unable to work for a period of at least 12 months. Where they differ is with SSDI benefits, you have to have a sufficient number of work credits. And generally speaking, we say that you have to have worked 5 of the last 10 years. There are always exceptions to the rule. The exceptions are also very black and white. They don't come up super often, so that's why we don't go through them here. But you do have to have a sufficient number of work credits. You can confirm that you have those sufficient number of work credits by actually logging into your My Social Security account. Make sure you're on the Social Security Administration's website. You'll be able to look at your work history, your earnings history, and make sure it matches up with what you believe your earnings history should be. After looking at that, you'll be able to see if you were to become disabled, what your estimated monthly disability benefit amount would be, and same with retirement, what your estimated monthly retirement amount would be at this point in time. Obviously, that's subject to change from month to month and year to year, depending on your situation and your working. But that is a really good resource to look at to confirm that you have a sufficient number of work credits for SSDI benefits. And then also, I get clients all the time that ask me, can you tell me what my benefit amount is going to be? And at the hearing stage, I can sometimes give you a little bit of insight into what it might be. But that My Social Security account is going to be the probably most accurate. SSI benefits, on the other hand, you do not have to have that work history. You do, however, have to have limited income and assets. We don't go through the income restrictions on the webinar. Those can be found online. They vary depending on family size. And so that's why we don't really talk about them on the webinar, because there's too many factors that can go into that. And then the asset restrictions. You cannot have more than $2,000 in assets if you are single, and more than $3,000 in assets if you are married and qualify for SSDI. So those are the two programs. As you'll see, they both do require that you be disabled and unable to work for at least a year. You don't have to go through that whole year before applying. And in fact, I often recommend clients don't do that, but to apply as soon as you think, or your doctors think, that you will be disabled and unable to work for that whole year. There are certain instances where Social Security will get your application, they'll look at it and they'll say, look, we need to see how this is going to progress. Certain things like cancer, strokes, we see that often in those types of situations where they want to see how you respond to the treatment, especially with cancer. They want to see what your response is going to be, to see if, it's kind of the way I look at it is they're saying, sure, right now you're disabled, but the question is it going to last 12 months? That's of course not what they're saying, but that's kind of my perspective, is that's kind of what they agree that there's something there. They just want to see how it's going to shake out, and if it's going to continue to be something that's going to prevent you from working. And same with strokes. Oftentimes they'll want to see, are you able to be responsive to treatment? Are there lingering impacts as a result of the stroke? So it's just kind of the longitudinal aspect of it, but you don't necessarily want to wait to see how it shakes out if you and or your doctors think that it's going to last for quite some time. Apply sooner rather than later, and let Social Security be the one to tell you, we're going to hold off on reviewing your file right now. Because sometimes they don't. They don't always hold off on reviewing the file. Sometimes they review the file. They can see how treatment is going, and they'll issue their decision either favorable or unfavorable based on that. And then, like I said, there are other instances where perhaps you were just diagnosed, and so they want to kind of see how it shakes out before getting that decision to you. So if they send you a letter saying we're holding off on your claim, it does not mean that it's going to be favorable in the end. It just means that they want to see how the longitudinal study is going to go as far as your treatment and the impact that it's going to have on your ability to function. All right, the 5-step evaluation process. When you first file a claim for disability benefits, Social Security is initially going to look to make sure that you qualify for whichever program you've applied for. And what they're going to do first is make sure that you meet the other prong, not the disability prong, but the other prong, which for SSDI is that you have enough work credits, and for SSI, it's that you have limited income and assets. So if you applied for SSDI and you don't have sufficient work credits, they don't even get to this 5-step process. They'll send you a letter pretty quickly saying, unfortunately, you don't have sufficient number of work credits, so therefore we cannot evaluate your claim because you wouldn't qualify for SSDI. And same with SSI. If you apply for SSI, but your income and assets exceed the threshold, or I should say your income or assets exceed the threshold, again, that's where you'll go ahead and you'll get that pretty quick denial where they'll say you're not eligible for SSI because your income and or your assets exceed our allowable threshold. As long as you meet the prong that needs to be met for whichever benefit you applied for, then they'll go to this 5-step evaluation process. And this 5-step evaluation process is basically the medical review of your disability. So first they'll look to see, are you currently engaging in substantial gainful activity? Substantial gainful activity is defined as working more than 20 hours a week, or in 2023, earning more than $1,470 a month. If you are engaging in substantial gainful activity, Social Security will deny the claim. They'll say you cannot be found disabled under our rules because you are engaging in substantial gainful activity. If you are not engaging in substantial gainful activity, it moves to step 2, where the agency will begin to review your medical records to determine, do you have at least one severe medically determinable impairment? And so that's an impairment that can be defined as severe because it has an impact on your ability to perform basic work-related activities and it's medically determinable because it's in your medical records. There's medical records that back up to support the diagnosis. If you don't have at least one severe medically determinable impairment, the agency will deny your claim there. They'll say you don't have any severe impairments. So again, by our definition, you cannot be found disabled. As long as you have one severe impairment, they'll move to step 3, where they will look to see, do you meet or equal one of the listings in the Blue Book? We'll talk about one of the listings in kind of detail in just a moment. I'll list 3 others that may be applicable specifically to arthritis. Listings, as you'll see, they're a high bar to meet. So you don't have to meet or equal the listing, and we'll talk about that in a minute as well. If you do meet or equal the listing, at step 3, you'll be approved. If you do not meet or equal the listing, then it'll go to step 4, where the agency will create a residual functional capacity for you based on your medical records, which is what they believe you're capable of performing on a regular basis. And they will look at that RFC and they will determine, can an individual with this RFC and the claimant's age, education, and past work experience go back to their past work? If so, you'll be denied. You'll say you can go back to your past work. If you cannot go back to your past work, they use that RFC, age, education, past work experience, and any transferable skills you may have, and they'll look to see, can you engage in any other work in the national economy? If you can, you'll get a denial. If you cannot engage in any other work in the national economy or your past work, then you'll be able to get a favorable decision. Here are some considerations to make. Adults can still qualify for Social Security disability benefits if their residual functional capacity, or their RFC, is less than what their past relevant work would require, and or the RFC prohibits them from engaging in substantial gainful activity on a regular and ongoing basis. So that can mean that you are unable to sustain competitive employment. Additionally, if you are over age 50, you may qualify for Social Security disability benefits using the grid rules. We've done webinars on the grid rules. We've done shorter videos on the grid rules. The grid rules are a very interesting aspect of Social Security disability claims, but they are really only applicable to individuals between the ages of 50, 55, 55, and 60, and then 60 to 65. And they change every 5 years. So that's why I gave those 3 different categories, because those are the 3 age categories plus the younger individual involved in the grid rules. So if you age-wise fall into a category that may be useful for the grid rules, I encourage you to look into those, because that can sometimes be helpful. It's not super black and white. That's the important thing to note too, especially between the ages of 50 and 55. The grid rules are helpful, but not as helpful as they are at 55 and up. Again, SSI benefits are only payable to individuals with limited resources, and SSDI benefits are payable to those who have paid into the system. Because arthritis it tends to affect older individuals, but it can affect children as well. We don't go through any childhood arthritis listings in the webinar today, but as far as children go with SSDI claims, if their parents are deceased, retired, or disabled, they may be able to qualify for SSDI benefits instead of just SSI benefits. That's something that you may want to reach out to us or even Social Security directly about to see if that is an option. Same with disabled adult children. If the arthritis or whatever the condition is has been in existence since prior to age 22 and there's medical records that prove that, then there may be a way to get a disabled adult child claim riding on the parents who are deceased, retired, or disabled, riding on their Social Security benefits. So again, that's something that does not apply to a lot of people, but it may apply to you or your child's situation. So it's something to consider. All right, here is the one listing that we're going to look at in detail. I'm not going to read it word for word, but as you'll see, it's listing 1409. It's for inflammatory arthritis. And so we see this a lot. This would be rheumatoid arthritis. Lupus can also sometimes come under here, as can MS. And you'll be able to see why if you kind of look through Um, as you'll see, you need a lot of medical evidence to meet or equal the listing. 1409D looks easy, but it is not easy. It's because it's kind of hard sometimes to have the medical evidence to show two constitutional symptoms or signs, as well as a marked limitation in activities of daily living, marked limitation in social functioning, or marked limitation in completing tasks in a timely manner. So it might look like that's the easiest way. It's oftentimes a little bit more difficult. Same with 1409B. All you have to do is show inflammation or deformity in one or more of your major joints of either an upper or a lower extremity. But you also have to show involvement of two or more organs or body systems, with one of the organs or body systems involved to at least a moderate level of severity, as well as at least two of the constitutional symptoms or signs. So this 1409B we've used in lupus cases before, so it is also relevant in more than just arthritis. Now, I'll leave this up for just a minute, and while it's up, I will also say, you can, if you search for listing 14.09, you can find it directly on the Social Security Administration's website. And so if it's something that you're looking at it now, and I am going too fast, all you have to do is Google, Blue Book listing 14.09, and the Social Security Administration's website should be one of the first ones that pops up. They're not going to have an ad for it, but it should be one of the first ones in the organic search. And so that can be something helpful to look at, because if you think that you maybe meet it, it can be helpful to show to your doctor sometimes and say, look, I'm trying to apply for disability. I haven't been able to work for 8 months. Can you, is there a way that we can have my medical records reflect these issues, and see if there's a way for that. Again, you don't have to meet or equal the listing in order to receive disability benefits. This is just one avenue. I find, unfortunately, that sometimes providers aren't as aware of the nuances of disability, and so they'll say that, oh yes, you're definitely disabled, but they don't realize that this is what it takes to meet the listing. And again, you don't have to meet the listing. This is just one way. Some doctors do look at that though, and they say, yes, absolutely. Here are the two organs that you have involved. They're involved to an extreme level of severity. And then you've also got severe fatigue as you are, sleeping 20 hours out of the day, as well as involuntary weight loss. You've lost X pounds over the last 3 months, 6 months, whatever it is. It can be helpful to have that. So this is the listing. Again, you can look it up directly by just searching it online, listing 14.09, and having that conversation with family members, friends, and doctors, anybody that you think may help. Here are 3 other listings that I mentioned. These may involve sometimes arthritis. There's listing 1.15, which is disorders of the skeletal spine that results in a compromise of the nerve roots. There's listing 1.16, which involves lumbar spinal stenosis. And then 1.18 is the abnormality of a major joint in any extremity. So all of those, they are not specifically for arthritis, but they can involve arthritic changes. As I've alluded to, and probably have said straight out, medical records are critical. Social Security cannot find somebody to be disabled without supporting medical evidence that shows that an individual is disabled and unable to work. So that's important to note, that medical records are important. Having a supportive doctor can be really, really helpful. And the issue in adult Social Security disability cases, particularly those that don't meet a listing, is not just, can you go back to your past work, but is there any job that exists in the national economy that you can perform? So functional capacity can also be relevant, especially going to that question. And objective medical records are important. When it comes to arthritis, we're talking about imaging reports, blood work, especially, like I said, as it relates to the inflammatory arthritis, if there's an RA claim, anything like that. and you've got the positive RA factor that will show up in blood work, that can be helpful. Anything objective that can show what's going on. Subjective medical records are also helpful, but objective medical records to really help tell the story are very important. All right. Finally, here we are at how an attorney can help you. Again, this is not a comprehensive list. It's just a list of some of the things that we either do most often, that we get questions about. And so again, this is not comprehensive. It's not everything that we do, but it is some of the ways that we can help. So one of the things that we can do is we can provide guidance on what correspondence from Social Security actually means. At least several times a week, we get calls from clients who have gotten a letter from Social Security before we do, and they want to know what this means. What do they need to do? Do they need to do anything? Do they not? And so that's one thing that we can help, so that way you don't have to wait on hold for 45 minutes with Social Security. You can send us an email or a message or give us a call, and that's something that we can usually help with. If we are already representing you or you contact us shortly after a denial, we can file necessary appeals, including requests for reconsideration, requests for hearing before an administrative law judge. In doing so, we can also review your medical records and your case file. We can discuss what additional medical records may be helpful to your case. And then when Social Security is sending you the correspondence and the forms, we can help to not only discuss what Social Security might be looking for in those forms, but also can help review them once you've completed them. So we as a firm make a practice of not filling out those forms. I view them as testimony without having to go before a judge. And so it's important to me, what you're going through better than anybody. And so that's, to me, the purpose of those forms, is it's to help tell Social Security what you're going through. It's sometimes for some people easier than being verbal in front of a judge, and sometimes it's more difficult. But either way, we're happy to review them. Like I said, it's not necessarily reviewing them to make sure that they're the right answer, because there's no right answer. The right answer is just what you are living with and dealing with. We do work with you to provide relevant updates back and forth from Social Security and to Social Security from you throughout the claim. If you have to go to hearing, we do prepare you for that hearing, and then we question you and any witnesses during that hearing. Now, when I say witnesses, I always have to kind of preface this with, I don't mean every single family member and your 3 best friends coming to sit and testify at the hearing. No. We do have a way to get that third party kind of lay testimony in, but really you are the primary witness in your hearing. There are limited circumstances in where a third party individual is also going to be a very good live testifier. But if you're a current client of ours, you know that we have other ways to try to get that witness testimony in as well, that can be helpful. But primarily the witnesses that we do question during the hearing are you, the vocational witness, and then any potential medical witness that Social Security has asked to be there as well. That is it. What I will do is we'll go ahead and we'll drop again in the chat a link to the scheduling call if you have questions. You can also give us a call directly, send us an email, whatever is easiest for you. That link will also be on the replay down below in the comments. Feel free to reach out to us. We're always happy to help in any way that we can. And again, if for some reason we cannot help you, we do try to point you in the direction of somebody or something who can, or give you guidance on what to do in your specific situation. So with that being said, thank you so much for joining us today, and have a wonderful day.